Hi, good afternoon, everyone. Thank you for joining us. And we'll be getting started in just a couple of seconds here. Welcome to our FOIA webinar. We'll get started in just a couple of seconds. All right, good afternoon again, everyone. Thank you for joining us. Thank you for spending a piece of your afternoon with us, or morning, or even evening if you're watching us after you get this link. My name is Raul Pinto. I'm Deputy Legal Director for Transparency at the American Immigration Council, and I will be your host today as we delve into what I'm hoping will be an entertaining and lively discussion on why you need to litigate your FOIA requests. With the help of my distinguished and honorable and just a fantastic panelists today, we're celebrating Sunshine Week. No, that's not when we celebrate the state of Florida, much to the chagrin of my co-panelist, Mark Prada today, since he's in Miami. It is the 1 week of the year when everyone, including government agencies, by the way, just seem to remember that having a transparent government and providing the public with information is actually good governance. So if you have FOIA requests, this is the week to do it. Just a couple of logistical items. We will try to leave about 10 minutes at the end for some questions from the audience. I'll also be monitoring the chat for your questions. We will likely not be able to get through all of your questions, so we're hoping to get as many as we can in. And since this is more a discussion than a panel, just feel free to drop the questions in the chat. We'll try to get to them again as much as we can during the talk and then at the end as well. We will be recording this webinar, so please be on the lookout for an email from the council after we're done with the recording. Without further ado, with me today is Mark Prada, a true FOIA litigation guru, co-founder of Prada, Urizar, and Dominguez in Miami, Florida, where he focuses on federal court litigation, including FOIA actions against immigration agencies. And I'm also joined by a friend, fellow North Carolinian, unless you've moved in the last few months. I really should have asked you that beforehand, but Daniel Mello, Senior Staff Attorney at the CARE Coalition in Washington, D.C. Welcome to you both today. I'm going to get right into it. Mark, I'm going to start with you. Why is litigating FOIA so important? What do you get out of it?
Time becomes a big issue sometimes. Let's say your client's in immigration court and ICE loves to stall on the FOIAs, and I used to notice that they would produce the FOIAs like after I fixed the immigration court case. Like, oh, that's super helpful, guys. Thank you for that. But and also with CIS, at least when they were very slow in the past, it was an important aspect, and also to get the documents you actually want, because there's sometimes something very specific you're looking for. Maybe you don't want the whole A file, and you know they're holding it back, and you're trying to hit every agency you can that might have the document, and then to set up a case to litigate on that as well, because you need the document for court.
Dan, what about you? What do you think? Why is it so important for FOIA litigation to be sort of in the immigration attorney's arsenal?
Yeah, I mean, I think to Mark's point, right, like apart from the timeliness, like we've recently found that, pushing the government on the FOIA piece in our habeas cases where we're trying to get folks out on those prolonged detention issues where I probably should have been reviewing their custody before we sued. It's been immensely helpful to start figuring out at least like where the breakdown is happening inside of the ICE local office headquarters. Is it just a couple of rogue officers that are doing these kinds of things, or is it something bigger, right? And so being able to push the government on the FOIA piece and getting some basic documents has helped inform strategy in some of our cases elsewhere. And I guess as just a general point, knowing what the government knows and thinks and believes about your client, whether that, again, is in the habeas context or in removal proceedings, I think is a huge plus, right? I mean, ICE, to me, gets away with a lot of what it does, in part because it thinks that nobody's watching it.
So practically, Dan, I'll go to you first on this question. Like, what does bringing a FOIA litigation lawsuit look like to you? Is it a standalone action that you have to go to federal court and take to federal court? Is it part of a bigger strategy? How do you make that determination? And what does it look like?
Yeah, and I'll admit up front, right, that I don't have like a robust sort of set of cases to point to, because we're being a little bit experimental right now in how we approach these in the habeas context. But for us, in this particular instance that I'm referring to, we filed it separately from the actual habeas action. And in part, we're going to be able now to utilize that because the government's going to have to produce the administrative record in the habeas action. But we've also got this FOIA going off in a completely different district court setting. And we'll be able to compare and contrast, for example, like, does the AR match up with what we're getting in FOIA and vice versa, right? So there's even just some advantages that way. I've also heard folks package FOIAs in together with habeas claims and with APA claims to maintain things like venue. I learned that from Brad Banas, that he'll often slide a few FOIAs in on his group benefits actions in district court, because if somebody tries to get mooted out, he's got the FOIAs then to keep that venue hook going for those folks.
Hey, Mark, I see you smiling there. What thoughts on that strategy? And then I'll get to a question that I have for you. But it sounds like you have some thoughts on utilizing that kind of strategy.
I think that's great because like that's a situation where you don't even really want the FOIA, but you're using it to like maintain an action live, to avoid like a court severing plaintiffs and sending them out to undo a joinder, right? So that's really crafty. And to Brad spent a lot of time at oil defending cases, so I'm sure he'd learned every trick in the book, and I just love speaking with him. There's always something new there.
So while we're on that, on getting crafty, because you've used FOIA in some cases that are not just necessarily getting your client's file just to kind of set the strategy, but rather you want to know what the government has on your particular client so that that can sort of educate where you're going or how you're going to claim certain things. And what kind of cases do you do FOIA requests?
It's when I know I want something specific, right? So I had a client that it's a long story, but let me do it fast. She was here in the 80s, iwi. She was married to a US citizen. They had a baby and they did an I-130. She was going to consular process like in 1990 before the unlawful presence bars. Well, she departs. He files for divorce when she's outside the country. And she ends up getting a fake birth certificate in Nicaragua, a new ID, a new passport, and a tourist visa under the false name, and gets admitted and comes back and demands her kid. And then her ex-husband says, I'm calling immigration if you try to get the kid back. Fast forward 30 years. She's coming down on a Greyhound bus to see some family, and CBP stops her. She ends up in proceedings and they charge her as iwi, and we did a FOIA quickly enough, and she had enough documents that we saw in a car application. We saw 245I. Because her son at that the baby from originally turned 21 and then 42B, and we threw everything in front of the judge to get a bond. And she tells me, look, I have a fraudulent admission. I'm like, okay, that means we need a waiver, right? But also, we don't need 245I. We don't need NACARA. We don't need 42B. We can just adjust you through your immediate relative son. So let's see. She lost the passport that she entered in, but she still had the fake ID from Nicaragua and the fake birth certificate. In fact, she owns land in Nicaragua under the fake name. So this is pretty fun. And we used that in sworn declarations, and filed FOIAs with CBP, with USCIS, with Department of State, and I think I might have tried OBIM. Like I just basically cast the net, right? And the administrative appeals lasted like a year, and the IJ, I started demanding discovery under Dent versus Holder, under 240C3, I think. In the INA, it says that you have a right to your admission documents, and TAs are like, do a FOIA, we don't give that over. So the judge is like, I'm not ordering them, just do your FOIAs and exhaust it. So I went through the whole mess. Department of State finally gave me the tourist visa numbers of the name, right? After we got a weird letter from like a law enforcement division at the Department of State. I'm like, statute of limitations ran, who cares? Let's just admit to the crime. And then we sued in district court on every single FOIA request after exhausting everything. And we also filed an I-102 to get a new I-94 explaining the whole story, and then they denied it because they're like, your admission was fraudulent, so we're not giving you the I-94. It's like, are you kidding me, right? So then this was a combo APA and FOIA claim. So the APA claim on the I-102 denial, and then the FOIA against every agency. And essentially, they gave me the text record from like some database showing the admission of her under the very narrow, because they didn't want to admit it was her, even though it's her face on the fake ID. Like, come on, this is the same person, right? And then after we got all that, I moved to terminate in immigration court. I'm like, well, you're charging 212A6 EWI, but she's been admitted, wrong charge. And there's multiple circuits talking about how fraudulent admissions still count as an admission. You just need a waiver when you're just, and the IJ terminated. So that was out of necessity, I guess, in that situation. And also, like, we couldn't just pretend she never got admitted. She had a fraud issue that needs a waiver, right? So that worked out.
I want to pull out a thread that you quickly mentioned, and it's actually one of the questions that I saw come through in the Q&A feature, not the chat feature. I apologize. Q&A feature, not the chat feature. So, sorry about that. But you mentioned OBIM, and actually FOIA, and what I've heard from many practitioners is that there is a certain fear that once you file a FOIA and there is personal identifiable information within the FOIA request, including person's address, like I think it asks for parents' names if I'm not mistaken, right? That there's a fear that you can put that person in danger of potential enforcement if you file a FOIA. What's your position on that? Do you file it or then do you switch requester, or what do you do?
You shouldn't have to have that fear, and I think it's really messed up that we reasonably have that fear. I do them anyways because we just need the info, right? So I had this one client, he was a UAC, and they never did anything to him, right? And so he was here 10 years later, like, hey, what are we gonna do, right? So I did a FOIA on him. I did the OBIM to get the A number, and then with the A number did the USCIS FOIA. One day they call him on a cell phone from ERO. Hey, remember us? We were going through all the old UAC files, right? Supposedly. And yeah, we needed to follow up on your case. And they took him into detention with a new NTA. And then, I had to prepare the 42B application for non-LPR cancellation and get a bond. And well, his case finally we resolved it after years later. But yeah, I think it's a real problem. I wish I could find out why that's illegal. But then again, you have 1252G, and I don't think you could ever sue to complain about that anyways in the INA. So, but it happened to me, and like, I don't know for certain it was because of the FOIA, but I am pretty damn sure it was because of the FOIA request. So yeah, because there was an NTA that never got filed on him, and then they just decided to. Yeah.
Yeah. So you've seen enforcement then on someone files a FOIA request, which is unbelievable. But and so I think practitioners have to sort of account for that and be wary of that. When they are sort of doing their filings. Dan, do you have additional thoughts on that, or what would be your strategy if you had a potential client that was removable, or that you had certain fears that there could be some enforcement once you file the FOIA? Because I had not heard about that. I had not.
Yeah,
I'm sorry.
Oh, go ahead, Mark.
Add something.
Yeah, absolutely.
My practice now is I never put the client's address or phone number on the G28s or nothing. It's just care of on my forms. So hopefully that can help. Sorry.
No, that's what I was gonna say is that in my current role, working with detained populations, they're very much already on the government's radar. So, it's a much less of a concern here. However, I in other settings where that was a very legitimate concern, yeah, adopted the very practice that Mark was referring to, right? There's like you give the absolute minimum amount of information, having informed the client that even that might still run some small risk, right? And that as long as they're comfortable with that, that's what we'll do.
So let's shift a little bit to kind of the strategy, the nitty-gritty of it. I guess you can always bring up a FOIA like by itself, right? In a complaint. How does that FOIA request and how does that aspect of the litigation play into your bigger case strategy? And along those lines, I did want to ask you, and maybe you can drop some comments in the Q&A as to, are you all filing FOIAs for every single case that you take on to find out where your client stands and what the government knows about them, or are you more selective? I'd love to hear your thoughts about that. Dan, you want to start with you on that one?
Yeah, in terms of case, it's still kind of like an enveloping learning experience for me, especially in the habeas context, because again, we're even just discovering things that we didn't know. For example, that ICE has recently, or fairly recently, seems to transition to conducting its post-order custody reviews through an electronic system that was referenced but not produced in some of our most recent documents, right? So again, on the flip side, where we're actually still litigating the habeas portion of this gentleman's case, those two things can just keep playing off of each other because we have the freedom and the flexibility, especially on the FOIA piece where we're already expecting some level of admin record on the other one anyway, to get a little bit more creative and I think also a little bit more aggressive with the government because we have less to lose here. And in terms of like how often and who I put them in for, I've just have made it a practice now with habeas, especially to put them in and to, honestly to the extent possible in some of the other contexts, if I have time and it's a straightforward request to go ahead and put it in because that half hour, right, like is basically preserving an issue for me to potentially litigate in the future if I need it.
Mark, what are your thoughts about that question? Sort of how do you utilize the FOIA into your case strategy?
So I usually decide this at the intake on a case, right? I ask people how you got here and if you've ever applied for anything at immigration. Like the moment they tell me they filed something or had some sort of contact, and I tend to err in favor of requesting the FOIA unless I feel they have enough documents that I don't need to look at it, right? So like if anyone has a CBP or ICE contact, like I want to see the IT-13s always, right? So I'll file FOIA for that. Very recently I had a client come to me for an I-130 and his notario for his TPS the last 20 years retired. So he's like, oh, I need to renew the TPS. I'm like, okay, well, do you have the forms? Of course you don't have the forms because the notarios don't maintain a file. So I did the FOIA to see all his prior TPS filings because I wanted to get the entry date right, and this is probably really unnecessary, but it was just to make sure that one, that there's no inconsistencies in his past filings, and two, that I don't create an inconsistency in the past filings. So, even with naturalization cases, I try to grill people about how they became an LPR, just to start because USCIS when they do Nats, it's like the main thing they do is try to find out if the adjustment was improper, to then hit you with that like you weren't lawfully admitted for permanent residence thing. So I try to do that in advance, especially guys with criminal history and things like that. So, unless they tell me like, oh, my daughter petitioned for me, I'm like, okay, there is no way they can say there was a fraud there. So let's just move forward, right? So, So that's me erring on the side of caution. I try to do it like every time I think it could be of value.
I like the fact that you said that the notario retired, and I wish all notarios would retire at this point. It's just so damaging to our cases, and I could also have that experience in my prior life representing individual clients where we had that happen, where so many of the things that notarial did we just didn't know about, and then FOIA becomes sort of your crucial tool to find out what happened in the prior applications, because they never had the files, right? The only ones that are going to have the files at that point are the federal agency. And so if the agency, then if you do that request and the agency doesn't reply within the time allotted by the law, by the FOIA, which is 20 days for a regular request, 30 days if there's extraneous circumstances or whatever the law says there. And at this point, I think it's usually translating into 30 days. Then you can take them to federal court, right? And that's kind of the beauty of the law. And it goes back, and I want to touch on this with you, Mark, because you mentioned that the judge told you in one of your cases that you had to file the FOIA and exhaust. Can you tell a little bit about the audience that may not be familiar with that lingo, and specifically when we talk about sort of FOIA requests, like what that actually means?
Okay, you can't. Okay, if USCIS produces a CD to you and you want to challenge the redactions, you have to appeal administratively. And every DHS has a set of regulations on there, because like the letter they send you would be like, oh, you have 60 days to appeal, or maybe it's really 90. Like I've seen those inconsistencies before. So I always follow the regulation where, like, for addresses and deadlines and all that, and it tells you how to exhaust. Um, and then DOS and DOJ have their own regs. So normally you have to exhaust through the appeal before you can go to district court. However, there is case law that says that if they don't produce timely, then it's like, um, I feel like those are district court cases that say that, though, in DC, but I'm filing in Florida, and like no one's ever challenged that with me before. So I don't think the statute says there's constructive exhaustion, but like the courts treat it that way. I might be wrong on that, but typically what I like to do is look at the DOJ FOIA manual. They have a website that's like for themselves. So that's their good case law. And even though some of it's favorable to us, so I like doing that as a starting point before I try to get like fancy and try to resist those cases. But yeah, so to get to your answer, the question, I mean, normally you have to exhaust, uh, but you don't really have to when they don't produce in 30 days. You could just file at that moment, and really it just becomes like a resource constraint issue, because like I'm not gonna sue on 100% of delayed FOIA responses. It's more like the urgency of the matter. So like that lady I was talking about, the IJ gave us continuances for a few years until we went through everything. I was really trying to get him to issue the order to like force them to produce the admission documents, and then we just had to sue at the end. And he let us play it out. But in other situations, you don't have that luxury.
I'm so glad you went there, Mark, because I think for us who do the FOIA requests for for policies and for procedures, there is a sort of level of determination that we need to make about resources, and do we want to take the agencies to court on day 31, or do we want to seem more reasonable strategically with a potential court and wait a little longer? It seems like you're going and doing the same math when it comes to individual cases and FOIA cases. Just does this case need it more than others? Correct me if I'm wrong on that one.
Yeah, pretty much. I mean, it's just more the urgency of the matter, because
Yeah.
we have a heavy caseload, so it's like I would, in an ideal world, sue on day 31 every single time and like demand
Right.
attorney's fees, and be the guy that leads Congress to change the law, right?
You wish. Dan, do
Yeah.
you have any other thoughts about sort of like do you file a lawsuit on day 31 versus waiting a couple of weeks or
Yeah, I mean, I don't think I have any really great advice. I know at least what I hear from other, folks, especially in DDC, is that if you don't have a great reason for doing it on day 31, you're probably going to get run out of court. But I that being said, I think there's plenty of justifiable reasons, and I'll just add that like FOIA is probably like the one statute for immigration practitioners where you can actively swing back at the government, and it has some teeth to it. It really does. And so that being said, like I wouldn't be afraid to try it, right? Because the worst case scenario is that you get told too soon. You may, blow, your filing fee, but you can always take another crack at it.
No, I don't think it's a question of necessarily dismissal. It's just kind of like, well, I think that the government in FOIA cases, at least in my experience with like more policy-based questions and issues and documents, it's like, they're so deferential to the client, and you have several decisions that defer to the government on that. At least, well, we couldn't, possibly get our FOIAs processed in time because we have, 100,000, and we can talk a little bit about sort of like the current backlog, but we get so many that we just don't have the resources to handle all of them, and so like that's sort of the concern there. But I do agree with something that Mark said before, which is I don't necessarily think or let me rephrase that. I think there's a constructive exhaustion if the government has not replied within 30 days, and I think you're pretty well into your within your right to file that lawsuit at day 31 because they haven't they haven't responded. And in my view, the advantage of doing that is that then you don't have to wait them out. You don't have to file an administrative appeal on a non-response, right? Because if you do, then you're risking that they're going to take their sweet time in providing you with that appeal. A files, I think, are a little different. And both of you can correct me if I'm wrong here, but A files are getting actually answered a little bit quicker, and so you are getting a response which you may have to appeal anyways. And we'll get into a little bit of A file stuff. But I do think that there's sort of an exhaustion issue when they don't reply. Mark, you came off mute. Correct anything that I said was
Yeah,
wrong?
I have two thoughts there. The way I understand the cause of action is that you're seeking production. Like, regardless of you're complaining about the delay or withholding or a proper search or so on, like it's the same cause of action at the end of the day. Like you're only seeking production. So I don't see how the statute distinguishes between any of that, right? So I think it's natural that the constructive exhaustion is in there, and I don't, unless in DDC they have like some judicially created case law of like you filed too early, even though the statute says otherwise. It's more probably you just make the judge angry, right? Like, um, and on the thing about the A file you mentioned about like USCIS, right? I randomly do policy requests for us, just for things that like I get mad about. Like the one I'm waiting for is the rules of ethics for like the 1-800 number customer service people. Right? And this a woman called me from the FOIA office once, and explained to me, I think she was like really high up there. I forgot her name. That like the NRC numbers versus the COW numbers is how they divide up the cases, right? So if you get an NRC number, they have like 100 people on staff, rough estimate of the number. But for the COWs, it's way less people on staff, and those are the complicated FOIAs. So like those people are super backed up forever. And she kind of like begged me not to sue her. I'm like, okay, I'll give you a little bit, right? So like, it was an interesting peek into how that works at CIS at least.
Let me shift gears a little bit because I know there's a lot of practitioners out there that may want to watch this discussion, may want to watch this video and say, I've never brought a case in federal court. I don't have that experience. I'll start, Dan, with you. Like, what is it like to file a request to file a request and then file a complaint and follow through in a lawsuit, and having to work with the U.S. Attorney's Office rather than working with OCC and the Chief Counsel's Office as we regularly do in immigration cases. Different, same, better, worse? What do you think?
Yeah, I mean, I think working with AUSAs is just in a league completely, wholly separate from working with OCC, right? Like I've had AUSAs on, different matters that are pleasant, a little short, combative, but it's still a walk in the sunshine, compared to most, OCC experiences that I've had over the years. Yeah, and in terms of going into district court, like, if you haven't used PACE or ECF before, it can feel a little clunky at first. And pleadings, all that stuff does feel a little bit different. But I will say, Raul, like, and I'm not just plugging this because we're here, like, I actually used y'all's guide really to get started, and to have a framework for putting together a complaint. And I'll say that, you, Mark, Andrew Free, there's so many folks within sort of our larger like FOIA immigration FOIA community that are willing to help, craft things, sort out questions around venue, around next steps. That, I think like the fear of going into district court is the hardest part. And once you've gotten past that, you will find that, again, you actually have something to swing back at the government with.
I knew I had invited you into this webinar and discussion for a reason, Dan. I appreciate the shout out on that.
Of course, I appreciate that $100 bill.
Mark, any thoughts of wisdom for folks who may be a little bit apprehensive of filing a federal lawsuit or like literally making a federal case out of it?
Look, the hardest part is the rules of civil procedure and the local rules, right? And just figuring out how do I serve process and all that. And then FOIA has special rules for that. The actual drafting of the complaint is very easy on a FOIA claim. I think we have like a 5-page template that I use on that, and it's just like, hey, FOIA is about, public transparency, a little bit of policy stuff, and then like, okay, I filed this request. It was received on this day. This is the number. It's been a long time. Give it over. Right. And like that's really all you have to put, right? And it's cool because the US attorney has 21 days to respond. So they kind of get in a mad scramble and they're contacting you faster than most lawsuits. I still kind of don't understand how it would play out like to judgment in a FOIA case because it doesn't make sense to me, right? Like you're not having a trial, you're not having discovery, there's no administrative record for summary judgment. I'm like, I still don't know how it litigates to the bitter end, right? Because normally, like here in Miami, there's one U.S. attorney who does FOIA actions every single time. And he's rough the first time you meet him, but like once he realizes you're a reasonable person, we kind of just like agree to a production deadline or a rolling production, and then like, I'll review it, and if there's something I'm mad about, or I'm like, hey, look, this is not what I want, he'll keep working at it to like make it go away. And I think his biggest concern is like, please don't seek attorney's fees. All right. And so then, I try not to, well, actually, I go, look, here's my hours and like, here's the EJA rate. And then I found out recently DDC has a FOIA chart rate, which is way higher than the EJA rate. So I'm like, look, man, this is my math. Lowball me. And then he'll cut it in 50%. I'm like, done. Like, I'm not fighting you, right? So I kind of developed that relationship that it plays out pretty easily. But I would still like to know, like, how do you get to judgment, like, on a fight over withholding of an exemption or whatever, right? Like, I have no idea.
No, for some of the folks that do the policy stuff and do those requests, I think it's on summary judgment motions, and they the government moves, then you reply and cross move, and then the judge was like, okay, well, here you go, and makes that determination. And so that, for example, if you're fighting over whether the government did a good search, then it would be remanded to the agency to do conduct that search. And so I think that's how you would actually do it. But that reminds me to get to a question, because you're saying you have a really great relationship with the U.S. Attorney's Office in your district, and FOIA does allow you to sort of, maybe using the dirty word a little bit, forum shop a little bit, right? And to pick your pick your venue a little bit more. Well, I'm going to get to that in 1 second, because I want to mention that a few folks have asked for Mark's template. Mark, if you have a template, that'd be fantastic to share. If you want to share that out, if you are willing, the council's step-by-step guide, if you Google it, and we'll actually share that resource with attendees after, when we share the recording of the video as well. We'll send you our step-by-step guide. Our step-by-step guide also has a template that you can utilize to bring FOIA lawsuits. But if Mark can share his, we can share ours. You can have sort of a couple of resources to rely on there. Let's talk about venue. Let's talk about where you're going to file this thing. And I do want to refer back to something that Mark mentioned before, that you want to be very, very cognizant of the local rules and where you're going to file, even before you're actually thinking about filing, because you actually have to be admitted in that federal district before you file. It's not like immigration court where you can just get the number and then go practice, right? Dan, where do you file your FOIA lawsuits?
At CARE, we've filed where we could on these couple of related matters, like specific to the location where the petitioner is, or where the detention issue was happening. But then on the individual one of the individual ones that we're actively pursuing, ended up going to DDC, not necessarily by choice, but ended up there anyway.
Mark, it seems like you're filing yours sort of in your district in Florida, right?
Yeah, normally. I joined the DC district court bar a while back, and I filed a few cases there. What I've learned is that they don't want immigration cases in DC anymore. I guess after Trump, there was all this initial success in DC district court, like on like memos and policy kind of things, but then people started filing their mundane mandamus cases there. And I believe that now makes the court and the U.S. attorneys there very apprehensive of like trying to settle these cases, because they don't want to like incentivize people going there. So I always kind of aim for the district where the requester is located, just because the local rural U.S. attorneys, or whatever you want to call it, they don't they're not committed, right? Like, I'm sure the finest FOIA litigators in all the land are in DC at the U.S. Attorney's Office there. And like, do you really want to pick the juggernaut on these things, or do you want some person that's like, oh yeah, I remember how to do this, I think, that are going to settle? I feel that's a big point to keep in mind.
I feel like you're bragging, because like we have to file all of ours almost in DC. I just want to point out that FOIA does provide you with the option of DDC always being sort of the home venue, right? And so, but for the most part, when the council, for example, who has our main office in DC, then we really don't have any additional options, unless we're partnering with another organization or partner with a local practitioner that can sort of try to get us out. And it depends on what makes more sense and where the client may be, where you want to be. But Dan, you try to stay away from DDC as well, don't you?
Yeah, I mean, and I think what I've heard in talking to most other practitioners and venturing into FOIA litigation is whenever possible, yeah, avoid DDC.
Yeah, and I wouldn't disagree with that. I want to shift gears a little bit, because obviously part of filing the litigation and filing your case actually also means filing a good FOIA, right? And crafting it in a way that sort of makes sense, so your argument is your arguments are strong, making sure that your day counters are good, right? I'll start with you, Dan. What steps do you take to make sure that your FOIAs are properly submitted and that the agency you've counted the days that the agency has to do? Maybe this is less of a problem now, and we'll talk about a little bit about like the new electronic filing systems. But any measures that you have taken to kind of make sure that the FOIA has been filed properly?
Yeah, I have been using particularly in ICE's case, like the online platforms to do the filings. And in the process of doing that, have discovered like a couple of things that are some drawbacks of that. But I do find one, it does create, a fairly instantaneous, at least in ICE's case, creates a fairly instantaneous record of the filing. You often get the notice, that email notice just saying, hey, we've got your FOIA, we're invoking the 10 extra days, blah, 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 blah. And then you have a place to go back to check on it, even if it's just to note that they haven't done anything constantly. On the flip side, though, it does make you automatically with the requester, and I think we can probably hold that for a minute, but it's like I think there's probably some downside in terms of if you are trying to think about doing that for an individual client with the idea of suing in mind in the future, you might have to put in some other safeguards in terms of what you put into the system to preserve them as the requester and you doing it on their behalf rather than you being the requester and being stuck litigating where you are as the attorney versus or your org is versus where the client is.
Mark, you've gone old school if I'm not mistaken, right? You're like paper. Let's do it that way. Can you tell us a little bit about correct me if I'm wrong on that, and why did you choose to do so?
So when I'm doing something specific in mind that I want, I don't like the forms. So I have a letter that I use, and then I'll have like a point heading that says scope of request. And I might even give like a little preamble saying, hey, you guys published some sort of memo or there was a lawsuit, and then in response to that lawsuit, you started changing your behavior, and with like some background and like, with that in mind, I am seeking X, Y, and Z, right? And then I might even like add exhibits for them to reference it, so like it kind of points them in the right direction. Because I guess there's this whole debate about like the reasonable search, and like you can't use the words any and all because then like that's unreasonable. It's like, what do you mean that's unreasonable? Whatever, right? So like I to be able
Fishing
to
expedition, I believe they call it. It's a fishing expedition. They don't like the words any and all because it's a fishing expedition.
well, I mean, like, I want all my records for my client. Like, what do you mean? Like, just give me everything you got. Why is that so hard? Right, all right. But if you're looking for something super specific, I like using the cover letters. Um, I am very disgruntled with the online filing system, so like, I don't even deal with them anymore. Like, I just train my paralegals, like, look, do the G28, do the G639, write a cover letter, always write in the form, see cover letter, like for what you're, and then like we'll type up a scope of the request, right? And then so that I have a hard copy of what's sent out. We'll do that online, often. But when I know it's gonna be super contentious and all that, then like I insist on doing it by mail. Like one, they're gonna respond slower, so like you don't get the acknowledgement letter in 20 days, sue on day 21. You're already late on the acknowledgement letter, right? So like meaning that they haven't invoked the 10-day extension that they always do on the acknowledgement letter, right? So especially on litigation, I'll do it by mail because like that way I can actually get the claim in on day 21 instead of like day 31 if they respond with an acknowledgement quick enough, right? So those are strategic thoughts there. I will tell you this, I once got an acknowledgement letter that says, oh, hi, you requested C cover letter, and we're working on it. I'm like, what? That's not what I requested. So um I don't know, it's like you're screaming into the void a lot of times with these FOIA requests.
Um, what does that do, Mark? And Dan, I know you have thoughts on this as well. But what does that do to the relationship between the attorney as the requester versus the client as the requester? And we talked a little bit about attorneys' fees before in this discussion, does that play into your thought process as you're making that determination? Mark, I'll start with you.
Well, okay, so the requester is the plaintiff. And it seems like USCIS with their portals and their forms try to make you the requester as often as possible. So that's why I'm talking about using G28s to put it in there to just like signal very clear as day. I'm not the requester because on the G28 I represent client and check the box requester on there, right? So even if the 639 doesn't really let you like make that clear, the G28 at least does, right? And it was more at first like I'm like, okay, I know this is important. I'm not sure why, right? Because are they really gonna move to dismiss because you have the wrong plaintiff on these cases? Like maybe not. Like that's just kind of a waste of the judge's time. But then attorney's fees, right? If you're filing as a pro se plaintiff, you can't get attorney's fees in federal court, is my understanding. So um if you're doing FOIA litigation, I mean, man, I'm sure that could be a business all in itself, right? Getting attorney's fees there, because it is easier to get attorney's fees under the FOIA than the EJA. I think that's probably the biggest incentive behind that.
Dan, any additional thoughts on that?
No, other than just to reiterate the earlier point about venue, right? That it's like, if I, Dan at Care, am the requester, that means that I only have DC because our office is in DC. Maybe there's an argument, a vague argument that I could file in Raleigh in the Eastern District of North Carolina where I am as an individual, but that would be an uphill. And then of course the default is again DC. So, if I'm stuck as the requester, then yeah, not only attorney's fees, but then I'm stuck litigating in the one place that I think everyone tentatively agrees is probably not ideal to do it with. And so conversely, I think that might be different, like that consideration may actually be different for some folks, depending on where their client is versus where their office is, so on and so forth.
Yeah, I'll expand a little bit on what Mark was talking about before, which is sort of the courts. At least there's some case law that, if you are filing pro se and doing the work pro se, then that's when you wouldn't necessarily be entitled to those attorney's fees, because the statute sort of the fee shifting statutes sort of see it as a attorney-client relationship. And so if an attorney is sort of appearing pro se on a FOIA request, and I think that relationship gets muddled, and that's when courts have said no, attorney's fees are not necessarily applicable here, even though the FOIA does allow them to happen. And that's why I think it goes to what Mark and Daniel were saying before, which is you want to make your intent clear that the requester technically is the client, and you are still the attorney. Dan, I saw you perk up a little bit on that. Do you have any additional thoughts or?
No, I was just going to add that FOIA, to Mark's earlier point, FOIA has baked into it the sort of catalyst theory on attorney's fees, right? So you get attorney's fees, or at least can get attorney's fees, even where you sue, the government coughs up the documents after you sue, and then you dismiss the thing. You can still get fees because they altered their position relative to the lawsuit, right? And again, I have no familiarity with any other statute in our line of work that allows us that gives us that kind of power, albeit a small one, but some kind of leverage in those suits.
I want to turn to some of the questions that we're getting. There is a lot of questions and comments about how long CBP is taking to fork over records. Mark, do you have any experience on that? And what are some strategies that you can utilize to kind of force them to give them the records? And litigation is probably one of them.
Well, the question answers itself. You have to sue them if it's taking too long. I've been doing CBP requests for clients who had a lot of non-immigrant visas and were traveling in and out, and like I want to get the history of their continuous presence and all that. So that moves pretty quickly in my experience. Like they kind of just do a printout for me from some computer system that they have, and then I can do the math on that, right? So, for example, like to do an ads on somebody who is always traveling. I think we had a client who worked as a stewardess on an airplane, and we had to do that. Beyond that, I haven't really done FOIA requests to CBP for anything else in the recently, so I couldn't comment on the delay.
Which agency do you hate the least as far as like delays are concerned?
USCS has gotten better.
Yeah.
And OBIM is pretty decent with the fingerprints.
Dan,
I
who
mean,
do you,
I hate
oh, go
them
ahead,
because
sorry,
like
finish.
the codes, right? And like they redact so much on there. It's like, come on, why'd you do that? Do I really have to fight you on that? And it's like, I could piece it together. This is like the thing with CBP, you get the OBIM, you get hits for like when they do their fingerprints on an application and like random things that I don't know why, and I almost feel it's like maybe they refresh the fingerprints or something like that. So
Yeah.
they try to like hide the reason why the person came up a lot of times. Um, so I mean, I think there's probably some value there in trying to like harass BIM through like some sort of litigation on these things, but I've never actually played that out in a case. It hasn't been like that big of a deal breaker on a strategy that I need to have that.
Dan, your thoughts on which agencies are better, which ones are worse?
I mean, I think post Nightingale, like, which shout out to those folks, right? That's an amazing piece of work. Like, that USCIS just has more of a shit together. Yes, it seems like they might be redacting more than they should be, but nevertheless, in terms of at least getting things moving again, USCIS is by far the easiest to deal with.
Yeah, and we've gotten some questions about like and Mark has mentioned this about specific documents because I think specificity sometimes can play in your favor even though it shouldn't necessarily. I think that the gist of Nightingale and the Nightingale case, which the council was a part of along with NALA and the Northwest Women's Rights Project and Stacey Tolchin and obviously Nightingale, just great team all around. Was is that it was A files, right? The delay was for A files, which obviously are the sort of the Rosetta Stone of finding out about your client's history. And at the end of the day, the new electronic systems actually don't have A files as an option, if I'm not mistaken, unless they've changed them in the past few weeks or so, right? You kind of have to put it on the other and say, no, I want everything. I want the entire case because I need to know what my client did in its entire immigration history. Whereas you can actually say and particularly instruct the agency to kind of fish out one particular aspect of the file. So if like, oh, there's a particular application that I want the government to provide, but that never works. Do you all use that strategy in like in looking at a specific document, or do you just go for the entire A file and then utilize sort of the Nightingale case to make sure that those returns are on time?
So I've been leaning towards other, and how do I do this easily? Everything about that form is for USCIS's convenience. Okay. If you click, I want the I-130, thinking, oh, they're going to send me the I-130 record. No, you're going to get the form, right? And like, I guess when you file online, or even if you file paper and they try to digitize like affirmative benefits requests, they kind of give you like this computer like printout with like the copy of the form scanned in it. And like they're like making these digital records for like each benefit request, right? So I've kind of started noticing that in the last few years. Like a Nats application will be like its own PDF, and it's like totally somebody did just print and made it from the computer, right? It wasn't like they actually got your filing and scanned it raw at that point. So I've had cases where like I want the A file just to get everything, but there's like an I-130 I want because again, notarials don't keep copies of anything. And like I'm not gonna consular process you on an approval notice without knowing what you actually submitted. right? So then the A file won't have the I-130, and you're like, what is going on? Then I'll do another FOIA with a copy of the approval notice. Like, I need this I-130. Okay, here's the form. I'm like, no, I need the evidence. And then it's on appeal. And then like I have 2 cases right now where we have like 6 FOIA requests because they keep playing games with us. And like either I just get the I-130 form or like the civil documents, but none of the relationship documents. And it's like, what are you doing, guys? Like either they're playing on purpose, like I don't know. I kind of suspect there's a little conspiracy because sometimes they just want to mess with you, right? Or it's just really like a combination of incompetence and trying to like do this factory like super efficiency, and then like you're not actually getting what you want, and like it's confusing very fast when all I want to do is just do like a 601A case, which shouldn't be hard, right? Um, yeah, so I really hate the online filing, to be honest with you. Like it's just they're trying to make their own lives easier, and like in the process, I guess they're learning from us, like how they're not doing it the right way. I would hope they're learning.
And for a moment, it seemed like the agencies were discouraging people from filing paper copies and trying to funnel everything through the secure release system. But I think everyone on this looking at this video should know that by filing a paper copy, you should not be sent to the back of the line. They shouldn't prioritize electronically. It's a first come, first served basis, and keep working on the entire file. And it doesn't matter if you've asked for one specific document or asked for the entire A file. They should move at the same speed. It doesn't. They shouldn't be prioritizing one over the other. Dan, you had additional thoughts?
No, I was just say, I mean, to the extent that they're processing, the no speed that they're processing everyone's, you get to be put in that same line, right? So the equally poor treatment gets handed around. No, I was just gonna also point out, with the online filing and using like some of that language, right? There's good case law from DDC about like capacious language like any and all. And yes, it's true, right, that like any and all in certain contexts really could be a massive universe of documents. But I think to Mark's point, right, like when we use it and the way that I try to craft my own FOIAs for individual clients is like, I want the pieces of paper with their name on it, right? Like, and that shouldn't be that hard to find. And so there's also really good case law out of DDC. I think the phrase that one judge used, like, FOIA is not a game of Battleship, right? Like, we don't have to land super technical hits on language to get what we're supposed to get. And so don't let they may raise those kinds of arguments. Don't let that deter you from asking for everything when you believe that there is an everything and you're entitled to it.
I think we'll have time for one more question, so make it quick, gentlemen. What what do they do? What do you do if you find out that the agency has committed an error? For example, like they closed your FOIA request by mistake or something like that. Mark, you were talking about sort of like the factory processing of it, and mistakes are made. What do y'all do?
I always just do an appeal. Like I know there's a FOIA liaison on there. Uh, but I feel like it's just easier to just prep the appeal and send it out and be done with it instead of monitoring emails or whatever and watching the clock on your appeal deadline. It's just I've never had any success with the FOIA liaison either.
Interesting. Daniel, do you have any additional thoughts on
Yeah,
that, or?
same. Like there's been a couple that I've appealed recently where like I've gotten them bounced back because they didn't like the certification form that I used for the non-citizen's identity, or you thought that USCIS was the only one that had the records. So yeah, also submit appeals because if you're not in court, even if they blew past their deadline but then made a mistake and deny your FOIA, you actually do have to exhaust your remedies unless you've already filed suit.
I think we have 1 more minute, so one more question, I think, and it's if you filed a FOIA request and they didn't acknowledge the receipt, which has happened, right? And within those errors, do you count that time for your lawsuit for to your 20 or 30 days? I think yes, absolutely. If you can prove that you've sent it out in that particular day and then they actually received it, and that means electronic portal that provides you with a copy of it, or if you've received like the green cards, the little mailing carts, if you're doing certified mail, any additional thoughts on that?
Yeah, I've sued in the past with like the copy of my filing and the tracking history. Like, you got it, guys. Like, and this is the right address, and like you can fix that mess. And then one time they're like, "Oh, we did produce like a year ago." Like, no, you didn't. I never got it, right? But whatever. So I mean, it gets resolved either way.
Dan, last thought on that?
No, same. It's like, I think it would be like any other thing that you're trying to prove if you don't have anything else from them.
It has been an absolute pleasure to talk FOIA and nerd out on these issues. Thank you so much. We'll be sending a recording of this discussion in the next 48 hours or so. So look for an email from the council. We'll be sharing our practice guide as well, and maybe some additional resources to include. Daniel Mello from the CARE Coalition, Mark Prada, thank you so much for joining us today. Thank you all for watching. I hope you enjoyed your time with us, and we'll see you soon. Take care. Thank you, everyone.